All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Michael Armando Rivera who's placed on community supervision in 2019 CR 5302 for the offense of possession with intent to deliver a controlled substance penalty group 1, 4 grams to 200 grams on December 3rd, 2019 for a term of 6 years? Is that you?
Yes.
All right, state.
Violated condition number 1, on or about the 5th day of September 2020 in Bexar County, Texas, the defendant, Michael Armando Rivera, committed the offense of possession of a controlled substance in violation of condition number 1.
How do you plead to that? True or not true?
State will waive the remaining.
Any objections to the waiver?
No, Judge.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 10 years in the prison? I'm sorry, yes?
Yes. Yes.
All right, knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
Are you sure about what's going on here?
Yes.
All right, so you understand whatever agreement you have with the state, the court doesn't have to follow that agreement? All right, you're gonna need to speak up so the.
Yes.
All right, so do you understand if I find violation of condition number 1 true, that the court could sentence you up to 10 years in the prison?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 1?
I don't know what you mean about that.
All right, so do you think you have an agreement with the state on what's going to happen with this motion to revoke?
Yes.
I don't have to follow that agreement. You don't have an agreement with the court. Do you understand?
Yes.
So I can sentence you up to 10 years just based upon your plea of true to violation of condition number 1. Do you understand?
Yes.
Knowing all of that, do you still wish to plead true to violation of condition number 1?
Yes.
All right, the court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion to revoke and sentence to 10 years prison.
And is there this new number 1? What's happening with that?
That is my understanding that he was sentenced on that, and I believe defense has the specifics.
Okay, he's
Yeah.
been sentenced on that?
Right, I have I'll tender to the court and the clerks, the judgment in the federal case. And I showed that to the state, and then this is the criminal complaint. And then I also have the docket summary from Pacer. And so if I can just put on the record the dates of incarceration.
But here's my question though. State, you don't have a possession of controlled substance that's been filed with your office?
No, Your Honor, that's based on the federal case.
All right, and you have no intention of filing?
No, Your Honor.
All right, yes.
Yeah, and so we're just asking, he's got, I think, 281 days in Bexar County Jail. And we're just asking for the court to acknowledge the dates that he was in federal prison. And from the documents that the court has before, it would be September the 5th, 2020, until he was booked to Bexar County, which is September 20th of 2025. And that, that's about 5 years, Judge. I think it's 5 years and 10 days, 14 days. So we're just asking for that credit as well, in addition to his Bexar County jail time.
All right.
And you want me to just hand it to the clerk?
Yes.
Okay. You want this?
All right. Are you asking the court to follow this agreement?
Yes.
Are you waiving your right to appeal?
Yes.
All right, the court is going to grant the motion, revoke, sentence you to 10 years in the prison, give you credit for any time served. This will run concurrent with the SA 20 MJ 1083. There is to be no residing in households with minors. And no unsupervised contact with minors. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. You can speak with the clerks to make sure they have the correct calculations.
And I don't know if my client wants to say anything, but, anything you want to tell him?
I be here 5 years ago with the other lady. Everything went good. I saw my serious paper. I know I did wrong. I lost a lot of my family, a lot of members. You know what I mean? I respect 187, you know what I mean? I like 187. But when I came the other day.
No. I mean, I guess with respect to
But
the
with
plea agreement,
With the plea agreement,
you know, I mean, as far as.
yeah, you did good. You know what I mean?
No, but as far as, I guess, just wanting to move on with your life. And
Yeah.
get this case over with, obviously you've already.
That's what I'm telling you. Look,
No.
I've been in the field for 5 years, and I lost a lot of my family. And I promise to you in here, I don't want to sell drugs no more. That's not for me. I did a lot of classes, rehab, and the facilities over there. I did RDAF, 500 hours. I did behavior. I did all that, and I think I'm gonna put this behind. You're not gonna see me no more over here.
Okay.
I promise.
Well, I'm hoping that's the case, because really with these charges, at some point in time, the police are gonna catch you. And then you're gonna end up either in prison, the state prison, or either the federal prison. And the federal prison, it's a lot of time when they
Yeah.
give it to you, but they give it to you in months. So you're just sitting there, oh, 60 months or 80 months doesn't sound that bad. And then you would do the calculations. You're like, whoa, wait a minute. So this is what I can tell you. If you have not truly changed, and if you don't get your life on track, it's not going to end well. So now and what I can tell you is when you're released from custody, it's going to be hard. You know why it's going to be hard? Because people are going to see your history, and people are not going to want to give you a job. The best way to be employed is to have a trade or skill that somebody needs. And I was telling somebody before, I've had clients before
Mhm.
who had major criminal history, and they're making major money legally. And you know how they did it? They went to trade school and they became a welder. Everybody needs a welder.
Let me tell you this real quick.
Mhm.
When I got this case, I know I make the bad decision to go to the Fed, but I chose somebody and then got me here and gave me this paper. But I mean, I'm not supposed to. I mean, man, he told me to take the box, and I did. You know, man, I did my mistake. I did my time, and it's time to do this one and go home and do me. That's
All
I was
right.
gonna say.
Well, just do better, okay?
Yeah.
All right. Good luck to you.
Thank you.
You're welcome.
Appreciate it.
You're welcome.
It's a plea bargain case, and you have the right to appeal, okay? This is not a plea bargain case. Okay,
It's just probation.
I'm sorry,
It's just probation we talking about, huh?
well, you're on probation, but she can take it away if she deems that appropriate. But this is a certification that you have. This is not a plea bargain case, and you have a right to appeal.
What does that mean?
You want me to? Judge, I'm gonna have to set it for a contested hearing because, client is asking pertinent questions about it, and, may we recall it next week sometime or tomorrow?
No.
I need
It's
to
going to
set,
be set at a contested hearing. Mr. Leal, we've been here since 9.
I understand, Judge.
All right. So here's the thing, Mr. Ellison, this is a contract with the court. It's not a contract with the state or with your attorney. So you can negotiate with the state, but it's not binding upon the court. So if you want a contested hearing, we will recall it back for a contested hearing, but it will be a contested hearing. The state will be bringing in witnesses to seek to prove up the violations that are in the motion to revoke. Do you understand?
No, I was just trying to see if I can get it continued. I was working. I was trying to. see
Now,
if I can-
here's the thing. You're not at the phase where I'm to listen to what your reasons for why maybe the allegations in the motion are true or not true. Where we're at right now is I am explaining to you that you can't reach reach a binding agreement with the state and have it binding upon the court. So what that means is, if you and the state come to an agreement, I don't have to follow it. Your range of punishment in this case, if I were to grant the motion to revoke, is up to 10 years in the prison. Do you understand?
No, I don't. 10 years.
Do you not understand, or do you not want to understand?
Don't understand. 10 years for what?
You're on probation for a third-degree felony. You understand you're on probation?
I missed the stipulation, so I didn't call.
Yeah, that's what they're alleging, that you didn't, that you were unsuccessful and that you violated or did not complete certain things that they asked of you.
My first
So we can either
violation
go forward now, or either I can set it for a contested. Which would you prefer?
was a contested.
Where they have to bring live witnesses to prove the allegations. Like these allegations that we went on.
Bring live witnesses to prove that I didn't meet stipulation.
5 CR 0034009 State versus Irvin Earl Ellison. Could I have parties announced for the record?
Galloway for the state.
Rafael Leal for Mr. Ellison.
And are you Mr. Ellison?
No,
All right, Mr. Ellison, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
yes, ma'am.
Did you understand it?
Yes, ma'am.
All right. Are you the same Irvin Earl Ellison who was placed on deferred adjudication in 2025 CR 0034009 for the offense of obstruction or retaliation on June 17th, 2025 for a period of 2 years? Is that you?
That's correct.
All right, state.
Violation of condition number 4 in Bexar County, Texas. The defendant Irvin Earl Ellison did then and there fail to report to the supervision officer as directed for the months of July and August of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
You waive and abandon the remainders, Your Honor.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. State, what are you recommending?
You in the court to grant the state's motion and turn adjudication of guilt against the defendant, revoke him and sentence him to 5 years in prison, based upon the plea of true, and we would take into consideration cause number 2025 PF 5850.
All right, in defense, what are you requesting?
Judge, I'm requesting that he be continue on probation, either defer or with a conviction. My client was homeless. He didn't have an address, was trying to get his life together. To his credit, he called the probation office, left a message telling the officer of his condition and what was going on. He was mainly focused on getting his life together, and perhaps did not appreciate that he needed to report beginning with the intake, and he failed to do that. But when you don't have a home, a roof over your head, no money, going hungry for all the, once he was released, that's what clouded his judgment, in my opinion, Judge. And we're asking, when he was arrested, when he was just got a telephone and was in the process of calling the office to report. And we're asking that the judge, that the court continue his probation and And because I don't think the solution, it is just to send him to prison. I think he should have that opportunity and perhaps take advantage of it.
So has he done anything?
He didn't have an opportunity to do that, Judge. He wasn't, he wasn't directed with an intake as to what to do or what to, or
What do
where
you
to-
mean he wasn't? So he wasn't told that he had to report?
I believe he was released, Judge, from either jail or from here when he took the plea, and to his credit, he called WARNS, and
So you're saying he didn't know that he had to report?
that's not what I'm saying. I mean, I believe he was told, except that he didn't register.
So he's never reported?
Never reported, except by telephone on one occasion.
Probation? Has he done anything? Has he ever reported?
His initial intake in court with me. I don't have any indication that he reported after.
All right, so you're telling me that Miss Abrams never told him?
No, not. He was told when he was released as to what he needed to do, and he was probably even given a number to call, and he did call that number, except that he didn't follow up with that.
He was granted probation on June the 17th. On June the 18th, I guess when he was released, there is a notation that that there was a voicemail from him. And after that, there was nothing else.
So you want to call your client as a witness?
Yes, sir.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
So I do so.
All right, you can lower your hand, state your name for the record.
Irvin Earl Ellison Jr.
All right, you may proceed.
Mr. Ellison, when you were released, either June 17 of this year or June 18, were you given a number of the probation office and perhaps even a name of your probation officer to report to?
Yes, as soon as I was released, I used the phone in the lobby to make the phone call, and I left a voice message.
And what did your voice message contain?
I told him my name, and told him that I was checking in, and that was that.
Now, at that point, when you made that telephone call, did you have your own cell phone at the time?
No, I did not have my own cell phone. I actually just got it the day of the new arrest.
So you use somebody's telephone, either an office telephone or some other telephone?
I used the lobby payphone. Right before you walk out of the doors, when you get your cards, you get your property.
Was that from the jail or from?
That is from the jail.
Okay. And what was your understanding? I mean, when you were given that telephone number, and were they your obligations? And were you informed of what your obligations were?
Well, I checked in. I knew that I would possibly have to try to make another phone call. However, I had no way of communicating or reaching out with anyone. So I would do small work, pick up trash and lots or whatever. I eventually earned myself a cell phone, and that's when I got arrested. And I was looking forward to actually making a phone call and continuing on with any said stipulation or whatever it may be. It wasn't.
So you were trying to work on a daily job or some other type of activity?
Yes, I was too.
Okay, and Did you have a place of residence at the time?
At the time, no, I didn't.
Where were you living?
I was on the streets. If not, I would try to check in the Salvation Army.
Okay. And did you know when you were released that you were supposed to report in person to the probation office?
After release, no.
What would you like? I mean, what's going to be different if the judge were to continue you on probation? What's going to be different? How can you assure the court that you're going to be compliant with your obligations of community supervision or probation?
For now, if I get released, I'll be able to make phone calls and actually keep contact. That way I can have thorough communication. I can follow through upon any stipulation that is given for probation.
And that's what you wish the court to do to reinstate you?
That is what I wish for the court to do, to reinstate.
And but the question is still going to be, why didn't you do that the first time?
Trying, out there trying to do better for myself.
But you understand that to do better for yourself includes following up on your obligations and your community supervision.
Yes, I do, and I do sincerely apologize for my mistake. If you give me another opportunity, I capitalize on it.
That's the way it is.
Okay,
Questions?
Mr. Ellison, so you were released from jail in around, like June of 2025, is that correct?
I'm not too sure. I'm thinking so.
It was earlier this year, right? Okay, and so when you took a plea on this case, correct?
Correct.
Okay, and you were placed on deferred adjudication, correct?
That's correct.
Okay, and the underlying facts of the case that you're here for today is because you told a police officer that you would fucking kill him. Do you recall that? At the Chick-fil-A?
Probably said something different, but I do recall communicating with the police officer, two of them.
Okay, and so it's your testimony that when you were released from jail back in June of 2025, before you took off from jail, you made a phone call to probation, is that correct?
That's correct.
Okay, but when you took a plea in this case, Ms. Abrams went over the conditions of probation with you, correct?
That's correct.
Okay, and she let you know that you could report in person or by telephone, is that correct, to adult probation, right?
That's correct.
Okay, and so she also told you that you could reach out to probation in email form, right?
I'm not too sure. I was told that it was
In person or phone?
right.
Okay, and so the way that you ended up in court here today is because you went to Walmart in September of 2025, about a month ago, correct?
Correct.
Okay, and you were placed under arrest at that Walmart, correct?
Wendy's. That's correct.
Okay, that's how you're here today, right?
That's
Okay, and so when you were at that Walmart, it was alleged that you took a pair of headphones that cost $157 and didn't pay for those headphones. Isn't that right?
That's right.
Okay, and so my question to you is, how did you get to Walmart that day, but you cannot get to adult probation to comply with your conditions?
Walked
You walked to Walmart,
to Walmart.
okay, and you acknowledge that you could have walked to adult probation to report, correct?
I don't even know where it's at.
So you weren't informed that it's across the street from the jail at 200 North Comal?
I don't remember that.
Alright,
I
and
just tried to make
so,
the call.
I'm sorry?
I was just trying to make the call, that way I can continue communication with.
Alright, and so you didn't, you were arrested, and then that's how you ended up here today, and you stated that in between the time that you haven't reported, that you've been trying to do better. Is that your testimony to the court?
That's correct.
Okay, and by doing that, are you trying to do better by committing thefts of headphones?
No,
Would that be considered you trying to do better?
ma'am.
You passed the witness.
No further questions.
All right. Is there anything else?
No, no.
All right. So, Mr. Ellison, I understand that when people are homeless, maybe they're not able to get from point A to point B. But you haven't done anything on probation other than pick up new charges. That's not good. And in this court, I always tell people communicate. And if there's an issue, we can try to solve that, but no one can help you solve your issues if you don't communicate with anyone. And one of the, I wouldn't say the worst thing, but being on probation and picking up new charges is not something good. Because that shows that you can find the wherewithal to steal, but you can't find the wherewithal to get in contact with probation, which is across the street from the jail. All right, this is what the court is going to do. The court is finding violation of condition number 4 true. The court will take in consideration 2025 PF 35850, give you credit for any time served, and the court will sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal, I'm sorry, the court is finding you guilty and revoking. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Like what just happened?
You have been revoked and you're going to go to the prison. And when I say go to the prison, they may end up paroling you from the jail. I don't know, because I don't know what credit you have in for time, or they may take you to the prison and process you there and parole you. But I've sentenced you to 4 years. Anytime that you've been in custody, you'll receive credit for that on this case. Legally, that is the law.
How much time?
I don't know how much time you have in. To the clerk, do you know how much time credit he has? I'm sorry, how many? 215 days. All right. Good luck to you.
Thank you, Judge.
You're welcome. And Mr. Lee, I think that may need to go to, I think you all get your copies, but then I think the state will have that,
Oh,
the original. But no, you have the copies.